Today, we begin in the middle of a moment many H-1B workers fear. A policy shift that employers had questioned, workers had protested, and immigration attorneys had warned against. A sudden announcement, a bright spotlight on salary figures, an administrative change asking questions that sound simple, but aren't. This shift didn't unfold over years. It unfolded in weeks. Weeks that could destroy career plans. Weeks that could separate families. Weeks that could force thousands back to uncertainty. One wrong calculation here, and you could be watching your American dream slip away tomorrow. What Department of Homeland Security did crossed a line that fairness advocates hoped would hold. And when that line broke, workers did not hesitate. They responded with anger, with organization, and with legal challenges. Most people panic in this moment. They make the same mistake. They fall straight into the trap. But today, you're going to do something different. For 18 months now, there had been whispers, not from USCIS headquarters, not from formal press releases, just whispers, that DHS was preparing something fundamentally different. DHS has been methodical, yes, but also aggressive in that approach. Their actions followed a pattern, a rhythm, almost a countdown. But what triggered concern in immigration communities this January was that the pattern suddenly went silent. Attorneys who monitor H-1B policy recognize the indicators, the sudden Federal Register notices, the quiet stakeholder meetings, the technical language buried in proposed rules, the sudden radio silence from official channels. And when DHS goes quiet, something loud is coming. The H-1B visa has always been competitive. Since 2014, applications have exceeded the annual cap of 85,000 visas. The old system was a pure lottery. Every petition had an equal chance. A software engineer making $65,000 had the same odds as one making $150,000. Random selection, pure chance, no preference based on wage level. But fairness, in government's eyes, doesn't always mean equality. Sometimes it means prioritizing what they call economic value. And that's where the trouble began. Early January, Department of Homeland Security detected what they described as final implementation timeline, including salary-weighted selection methodology not seen in over a decade of H-1B administration. These are actions DHS only takes when signaling something specific, a major policy overhaul, a shift in enforcement priorities, or a complete restructuring of who gets to stay. Observers weren't sure which one applied, or whether all three did at once. But one thing was clear. DHS was changing its entire selection strategy. And when that happens without adequate transition period, workers pay the price. The system launching February 27th operates on a fundamentally different principle. Instead of treating every H-1B registration equally, it assigns selection weight based on the proffered wage. Higher salary equals higher selection probability. Lower salary equals lower chance. The government calls this beneficiary-centric selection. Workers call it discrimination by paycheck. Here's how the mechanics work. When an employer submits an H-1B registration, they must include the proffered wage. USCIS then sorts all registrations into wage-based tiers. Registrations offering wages in the top percentile get selected first. Middle-tier wages get selected next. Lower wage positions fight for whatever slots remain. It's not a lottery anymore. It's an auction. DHS published the final rule in January 2024. They claimed this approach would reduce fraud, increase wages, and prioritize the most skilled workers. But the implementation timeline gave employers and workers almost no time to adjust. Companies that had already planned their 2025 hiring around the old system suddenly faced a completely different playing field. The warning issued by workers' advocacy groups today was not routine. It was not symbolic. It was urgent. Town hall after emergency meeting described the move as discriminatory, economically destabilizing, and most importantly, legally questionable because it bypassed normal Administrative Procedure Act requirements. But strategy only works if the other side hesitates. DHS did not. Their response was among the most aggressive seen in modern H-1B administration. Multiple lawsuits have been filed challenging the wage-weighted system. Immigration attorneys argue DHS exceeded its statutory authority. The Immigration and Nationality Act doesn't authorize selection based on salary. It authorizes selection of specialty occupation workers. Specialty occupation status depends on job requirements, not compensation level. A software engineer making $70,000 in Ohio is just as much a specialty occupation worker as one making $140,000 in San Francisco. But under the new system, only the latter has a real shot. Today, court filings confirmed that plaintiff organizations launched constitutional challenges targeting DHS leadership, including arguments that had recently been validated for what analysts believe was establishing precedent for Administrative Procedure Act violations. They acted before DHS could finalize implementation guidance. They targeted the arbitrary February 27th deadline. They targeted the lack of economic impact analysis. They targeted procedural shortcuts connected to emergency rulemaking authority. This wasn't symbolic. It was actionable. And that's what made the warning so urgent. The economic implications run deeper than selection odds. Employers in lower-cost regions suddenly face impossible choices. A tech company in Austin can't compete salary-wise with one in San Francisco. Not because the work is less valuable, not because the worker is less skilled, but because cost of living differs. Under wage weighting, geographic location becomes destiny. Companies outside major metros lose access to international talent. Workers willing to build careers in emerging tech hubs get shut out. The rule also creates perverse incentives. Employers might inflate initial salary offers just to win the lottery, then adjust compensation after approval. Workers might chase higher-paying positions they're not suited for just to improve selection odds. The system optimizes for gaming, not for matching talent to opportunity. Universities and research institutions face particular challenges. Academic positions rarely match private sector salaries. A postdoctoral researcher making $55,000 at a university lab has virtually no chance under wage weighting. But that researcher might be working on breakthrough cancer treatments or artificial intelligence safety. Their economic contribution isn't captured by their paycheck, yet the new system treats them as lower priority. Nonprofit organizations suffer similarly. A data analyst working for an environmental advocacy group makes less than one working for an oil company. But both perform specialty occupation work. Both require bachelor's degrees in specialized fields. Under the old lottery, both had equal chances. Under wage weighting, the nonprofit worker gets pushed to the back of the line. DHS claims the system reduces fraud by making it harder for consulting companies to flood the system with low-wage petitions. There's truth to that concern. Some staffing firms have historically submitted hundreds of petitions for the same workers, artificially inflating selection odds. But wage weighting is a sledgehammer approach to a problem that needed a scalpel. It punishes legitimate lower-wage workers to stop fraudulent high-volume filers. The rule also fails to account for wage progression. A recent graduate making $65,000 today might make $120,000 in 3 years. But they'll never get that chance if they can't win the initial lottery. The system locks out early career workers, even those with extraordinary potential. It optimizes for current salary over future contribution. Workers have responded with organized resistance. Online petitions have gathered tens of thousands of signatures. LinkedIn posts documenting personal stories have gone viral. Immigration attorneys are offering pro bono consultations to affected workers. The message is clear. This isn't just a policy change. It's an attack on opportunity. Some employers are considering workarounds, offering signing bonuses to inflate reported wages, restructuring compensation packages to shift more toward base salary, relocating positions to higher wage markets. But these tactics have costs. They distort hiring decisions, waste resources, and ultimately disadvantage workers who can't or won't game the system. The February 27 implementation date adds urgency. The 2026 H-1B registration period opens in March. Employers have weeks to adjust their strategies. Workers have weeks to understand their odds. And everyone has weeks to decide whether to challenge the system or adapt to it. Court challenges might delay implementation. Previous H-1B rule changes have been blocked by federal judges who found procedural violations. If a court issues a preliminary injunction, DHS might be forced to revert to the old lottery system for the 2026 cycle. But that's not guaranteed, and workers can't base their futures on judicial outcomes. The wage weighting system also raises broader questions about immigration policy philosophy. Should the United States prioritize highest earners, Or should it welcome talent across the economic spectrum? Should a nurse making $70,000 have less access than a financial analyst making $90,000? Both are specialty occupations. Both fill labor market needs, but wage weighting treats them differently. There's also the question of who benefits. Large tech companies with deep pockets can afford to pay premium salaries to win the H-1B lottery. Startups and small businesses can't compete. The result is market concentration. Big companies get bigger. Small companies struggle to scale. Innovation suffers. International students face particular uncertainty. They've spent years and tens of thousands of dollars on U.S. education. They've built networks, developed skills, and invested in American careers. Now they're being told their chances depend on landing a six-figure job offer. For many, that's simply not realistic in their first year out of school. The system turns their investment into a gamble. Families are caught in the middle. H-1B workers support spouses on H-4 visas and children who've grown up in America. When wage weighting reduces selection odds, it doesn't just affect one worker, it affects entire households. Kids face uncertainty about whether they'll stay in the only country they remember. Spouses face career disruption. The human cost extends far beyond employment statistics. Some workers are considering alternatives. O-1 visas for individuals with extraordinary ability don't have caps or lotteries, but they require extensive documentation and aren't available to most workers. EB-2 or EB-3 employment-based green cards avoid H-1B entirely, but involve years-long waits. L-1 intracompany transfers work only for employees of multinational companies. For most workers, H-1B remains the only realistic path. The wage-weighted system also creates timing pressures. Workers on optional practical training have limited windows to secure H-1B status. Miss one lottery cycle, and they might have to leave the country. Under the old system, they could try multiple times with consistent odds. Under wage weighting, their odds depend on finding progressively higher-paying positions. That's not always possible, especially in specialized fields with established salary ranges. Employers are recalculating their immigration strategies. Some are shifting positions to Canada or other countries with more predictable visa systems. Others are reducing their reliance on international talent entirely. The chilling effect extends beyond H-1B. If the United States signals it only wants highest earners, talented workers might choose to build careers elsewhere. The rules defenders argue it protects American workers by ensuring H-1B visa holders earn competitive wages. But that logic fails scrutiny. The H-1B program already requires employers to pay prevailing wages. Adding wage weighting doesn't protect American workers. It just creates a higher barrier for international ones. American workers aren't helped when an H-1B position goes unfilled. They're helped when labor markets function efficiently. There's also the question of measurement. How does DHS determine appropriate wage levels? They rely on Department of Labor wage surveys that vary by occupation and geography. But those surveys have limitations. They don't capture total compensation. They don't account for benefits. They don't reflect real-time market conditions. Using them as lottery selection criteria introduces systematic errors. Workers are sharing stories online about how wage weighting affects them personally. A biomedical engineer working on medical devices described how her $75,000 salary reflects industry standards in her field, but puts her at the bottom of selection priority. A data scientist at a university research center explained how his $68,000 academic position can't compete with $130,000 private sector offers, even though his research has broader societal impact. These aren't abstract policy debates. They're people's lives. The implementation timeline compounds these concerns. February 27th leaves almost no room for adjustment. Employers who've planned 2025 hiring budgets can't suddenly increase all H-1B salaries by $20,000 or $30,000. Workers who've accepted job offers based on the old lottery system now face drastically reduced odds. The rushed timeline suggests DHS prioritized speed over fairness. Immigration attorneys are preparing for litigation but also advising clients on immediate strategies. Document everything. Understand your wage percentile. Consider whether employer can adjust offered salary. Explore alternative visa categories. Prepare for the possibility of having to leave the United States. These conversations happen daily now in law offices across the country. The psychological toll is significant. Workers who've built American lives now face uncertainty about their futures. They've rented apartments, established credit, made friends, joined communities. Wage waiting doesn't just threaten their employment status, it threatens their entire sense of stability. The stress affects job performance, mental health, and family relationships. Some observers argue wage waiting is just one step in a broader shift toward merit-based immigration. But merit is subjective. Is a worker's merit measured by salary, by education level, by years of experience, by innovation potential? Different metrics yield different results. Using salary as a proxy for merit ignores countless other contributions workers make. The international implications matter too. Countries compete for talent. Canada, Australia, the United Kingdom, and others are actively recruiting skilled workers. When the United States makes its system more restrictive and unpredictable, other countries benefit. Brain drain doesn't just affect source countries anymore. It affects destination countries too. As the implementation date approaches, more details will emerge about what DHS hoped to achieve. But one thing is already clear. Knowing this right doesn't make you a criminal. It makes you smart. It means you're prepared. It means you're protecting your family. Share this video with your family. It might save their life one day. Subscribe to USA Immigration Path for more protection. We protect you with real information as the next phase unfolds.